Okay, good afternoon. Planning Commission's in session. First item is a roll call. Julie, will you please call a roll?
Commissioner Schwartz.
Here.
Commissioner Peugeot.
Here.
Commissioner Lodge.
Here.
Commissioner Jordan.
Here.
Commissioner Higgins.
Here.
Vice Chair Campanella.
Here.
Chair Thompson.
Here. Are there any changes to the agenda?
No changes to the agenda.
Any announcements?
Just an announcement that the meeting of December 17th will be canceled, and the next meeting of the Planning Commission is January 7th.
Okay. And we're not meeting on Christmas. That's all up to Santa Claus, right? Okay, next item is a review of the minutes of November 5th and the resolution along with the two resolutions along with those minutes. Any changes, suggestions? All right, then can I have a motion to approve the minutes and the resolutions?
So moved.
Second.
Any discussion? All in favor?
Aye.
Opposed? No opposed. Next is the review of the minutes of November 12th and the resolution that goes with that meeting. Any changes or corrections? And can I have a motion?
Excuse me, Chair Thompson, I had one suggestion
Okay.
that I'd like to be read, if you can, please.
Chair Thompson, Commissioner Campanella had the suggestion of adding under Brian Cornell's, when he gave the presentation, so on page 3 of item 4, which is 634 Anacapa Street, we'd like to add, he stated that under the city's previous variable density ordinance, 7 to 12 units could have been built depending on the bedroom configuration. To have it clearly in the record what could have been built under the previous program.
Okay. Any other suggested changes? Okay, then can we have a motion to approve as
So
amended?
moved.
Seconded.
Okay, a motion and a second. All in favor?
Aye.
Any opposed? That takes care of that. Moving on to the next item on our agenda is a recommendation to the City Council regarding the cultivation of cannabis. And it seems like we have several attorneys here today, so we should be very legal. Okay, can we have the staff report?
Yes. Good afternoon, Commissioner or Chair Thompson, Commissioners. I'm Tava Ostringer, Assistant City Attorney, and I'm going to be giving the presentation today on the proposed marijuana cultivation ordinance. This ordinance amendment is being brought to you at the recommendation of City Council as a result of recently enacted legislation known as the Medical Marijuana Regulation and Safety Act. And before I get into a discussion on the ordinance itself, I wanted to go ahead and give you a brief overview of the legislation and its impacts on local jurisdictions. The Medical Marijuana Regulation and Safety Act, also known by the unfortunate acronym of MRSA, is a comprehensive piece of legislation that regulates all aspects of medical marijuana regulated activities. So that's from cultivation, transportation, distribution. The legislation was enacted to expand upon existing legislation under the Compassionate Use Act and the Medical Marijuana Program Act, all of which allow for and provide for a criminal defense to the possession and cultivation, either personally or collectively, of marijuana. It provides a little more clarity to what was an otherwise ambiguous area of the law, and that was the extent to which local jurisdictions could enact land use regulations pertaining to medical marijuana, and in particular, medical marijuana dispensaries. This legislation actually increases and reinforces local control and the city's rights to enact their local land use regulations, and it's been supported by the League of California Cities. It's comprised of 3 distinct bills: Assembly Bill 243, Assembly Bill 266, and Senate Bill 643, all 3 of which were signed into law by Governor Brown on October 9th and they will become effective as of January 1st, 2016. I'll take a moment to go through each of the bills so you have an understanding of how they work together and each one impacts the city. I'm going to start with Assembly Bill 266. I start here because it really is the largest of the three pieces of legislation. It regulates all aspects of medical marijuana activities with the exception of cultivation, which we'll get to a little later. It establishes the Bureau of Medical Marijuana Regulation under the Department of Consumer Affairs to enforce the new licensing requirements and regulations established under MRSA. It reinforces particularly local rights and local city jurisdictions to control marijuana, and it does this through a dual licensing structure between the state and local governments. In this particular case, a dispensary operator must first obtain a local permit and show compliance with local laws before it can obtain a state permit. And if, for some reason, a dispensary was to have its local permit suspended or revoked, then so too would the state license be suspended or revoked until the local permit could become reinstated. Similarly, it works conversely. If the state license is suspended or revoked, then the right to operate at the local jurisdiction is also suspended or revoked. It creates licensing categories for these various marijuana activities. So it's going to create a license category for testing, transportation, manufacture, distribution, and dispensaries. And within this licensing structure, a licensee may only hold a license in up to 2 categories, with the exception of testing. And testing, you can only hold one single license. What's new about this bill and what we haven't seen before is that it's also going to impose minimum testing requirements on all marijuana that's cultivated and distributed. So that aspect is important for the health and safety of users. It's also going to allow state licensed dispensaries to engage in mobile sales and mobile delivery of marijuana unless a local jurisdiction has an ordinance in place that regulates or prohibits mobile delivery. This obviously is of particular concern to cities, but it's not of an immediate concern because the state has indicated that it doesn't intend to issue licenses until approximately January of 2018. So the cities have a bit of time to consider impacts to mobile deliveries of whether they want to allow it in their particular jurisdictions. And because the state won't be ready to issue licenses until approximately January of 2018, any dispensaries that presently have a local permit or get one before that time will simply operate exclusively under the local permit. Senate Bill 643 really has the least impact on cities. It's primarily focused on controlling physician recommendations of medical marijuana. One particular thing that I'd like to point out is it kind of gets rid of that telephone call recommendation. A patient must now actually be examined by a physician before the recommendation can be issued, or that would be considered unprofessional conduct by the physician. But really, the important part of this bill that's important to cities is it upholds our local authority to levy fees and taxes with regards to the sale of marijuana from dispensaries. So that brings us to Assembly Bill 243, which really is the driver of this proposed ordinance. Assembly Bill 243, its primary purpose is to control the environmental and safety impacts associated with both indoor and outdoor cultivation of marijuana, which could result from pesticides, deforestation, water diversion, excessive water use, electrical. It is going to be overseen by the Department of Food and Agriculture, who will have the exclusive licensing control with respect to cultivation. And under this bill, there's actually a very expansive and broad licensing scheme with the type and scope of cultivation that's going to be allowed. It has up to 10 licensing categories that range from as small as an indoor grow with up to 50 plants, to nurseries, to outdoor grows as large as 1 acre. So it's really quite broad. And unlike the other two bills, which really enhanced local control, this is the one particular bill that's clawing back local control. And I say that because unless a city has an ordinance in place on or before March 1st of 2016, the state's going to be the sole licensing authority, and cities will not be able thereafter to enact any land use controls with respect to cultivation of marijuana. So what's the impact on all this legislation to the city? Well, the city presently has its marijuana dispensary ordinance. This is not in direct conflict with that ordinance, but what's important to point out is that the city does not have any land use ordinance regulating cultivation. So what that means is unless we have an ordinance in place by March 1st, we will be subject to state regulation and will be left at the whim of the state as to the type, size, and location of cultivation that's going to occur in this city. So with that being said, the City Attorney's Office and the Community Development Department requested direction from Council on whether or not they wanted to regulate cultivation of marijuana and to what extent. And on November 10th, Council unanimously directed the City Attorney's Office to draft an ordinance regulating the cultivation of marijuana and then to return to Council on January 12th for its introduction. And that's just what we did. The proposed ordinance will amend Chapter 2887 of the zoning ordinance by adding Section 300, and it will specifically regulate and limit cultivation of marijuana in the city. And just for reference, I didn't know if anyone had ever seen a picture of it, but this is a picture of marijuana being cultivated. The photo on the left is outdoor cultivation, and the photo on the right is indoor cultivation, and both were taken within the city of Santa Barbara. Now, Council was very specific in how they wanted and to what extent they wanted to limit the cultivation of marijuana in the city. So the new ordinance only allows for cultivation of 100 horizontal square feet of marijuana by a qualified patient for his or her personal use that occurs at his or her lawful residence. And it specifically prohibits the cultivation of commercial marijuana anywhere within the city. Now, the state has considered cultivation of marijuana to be an agricultural activity, and the city's present zoning ordinance allows agriculture to occur in just about every zone. So in order to kind of close the loophole and ensure that no one attempted to try and get cultivation in under an agricultural use, this ordinance will specifically carves out marijuana and exempts it from an agricultural use. And finally, one important aspect of this ordinance is that it does provide for a public nuisance provision. So even though the marijuana may be being cultivated lawfully within the confines of what's required under the ordinance, if it's creating an impact to the health and safety of the community, it still can be prohibited. So, what are the anticipated effects? Well, I think most importantly and most obviously is that this ordinance is going to allow the city to retain local control and decide for itself how it wants to limit the impacts of cultivation of marijuana within its jurisdiction. Now, obviously, the cultivation of marijuana can have an impact on everyone within the community, and in particular, especially since it's going to be allowed in legal dwelling units, and that's not going to be limited to, say, residential areas. It could occur within a commercial zone if that resident is legally permitted to be there. It can also occur in multifamily apartment units. So for this reason, I think it's important to just go back to the public nuisance provision and recognize that there is that mechanism if some cannabis is being cultivated in the confines of the code. The community has an option and to get rid of that cultivation if it's causing an impact to health and safety. And another area of the community that might be impacted are primary caregivers. Under the Health and Safety Code, primary caregivers are allowed to cultivate marijuana for a qualified patient, but that's no longer going to be the case under this ordinance. This ordinance specifically limits cultivation to qualified patients. So that's not to say, however, that a primary caregiver couldn't go to a dispensary to obtain the marijuana for the qualified patient. Just simply means they won't be able to cultivate it. And that brings me around to dispensaries. There may be an impact to the city's permitted dispensaries, and that is because the dispensary ordinance provides that collective members of the dispensary must collectively cultivate that marijuana within the Santa Barbara County, Ventura County, or San Luis Obispo County. And while that's still the case, that cultivation cannot now occur within the city. It's going to have to occur elsewhere outside of the city. So the City Attorney's Office, in conjunction with the Community Development Department, is recommending that the Planning Commission forward the proposed ordinance to City Council for introduction. And I'm happy to answer any questions you may have.
Okay, thank you. I would open the meeting for public testimony, but we don't have anybody from the public. So does anybody from the commission have questions for City Attorney's Office or staff? Commissioner Peugeot.
Thank you. I have questions in a couple of areas. So let's start with the cultivation. Some things that I don't understand about the way that the 100 square foot cultivation provision works. We have a current ordinance for dispensaries, which I think dispensaries and collectives are, a dispensary is a type of collective, I believe, and a collective doesn't necessarily have to be a dispensary. I think that's the way it works, but maybe you can clarify that. Just from, I think, state law definitions of collectives and things, I believe. But assuming that, unless you want to correct me on it, previously on another application, we got some excerpts from the municipal code about collectives, and in this case, a dispensary. And that one of those provisions, which is 28.80.080 G3, cultivation of medical marijuana, by collective, says the collective cultivation of medical marijuana shall be limited to the collective members and management members. And then it has that list of Santa Barbara, Ventura, San Luis Obispo counties, and then some other provisions. So because it says Santa Barbara County, but yet this ordinance appears to kind of, to me, it sounds like in conflict with that. How do you rectify that? Don't we need to change that language too?
Commissioner Peugeot, in regards to your first question regarding whether a dispensary has to be a collective or not, yes, under our zoning ordinance 2880, a storefront dispensary does have to operate as a collective. However, that's not to say that someone could not have a collective. We don't regulate collectives. We only regulate storefront dispensary collectives. So you had it right.
Okay.
With respect to the dispensary ordinance regarding where and how it's cultivated in what areas, it's not in conflict. The present proposed ordinance is not in conflict. It can occur within the county of Santa Barbara. It just now can't occur within the city. So it can occur anywhere it's allowed lawfully within the county of Santa Barbara, just not here.
That's going to take some explaining to people, I think, because it's not readily seen by the language. So that must be a nuance that you're really going to have to spell out for people. The other part of this, let's see, there's some related questions on this that just still confuse me. So we're allowing 100 square feet for personal use in residential, well, in residence, I guess residential property, not zoning. I understand it's not zoning. It could be any zone, and if it's a residence, you can use it. I get that. But the idea of a collective under state law allows people to kind of do things together. Does the state law also allow us to say, I mean, what do they do? What does a collective do if it doesn't commonly grow stuff? I mean, what else would a collective then do? Isn't that the main thing they do?
Yes, but they would no longer, under this present zoning ordinance, you can no longer collectively cultivate marijuana within the city of Santa Barbara.
What else does a collective do in general? I mean, a collective, anyway, I'm just confused about what's left for a collective to do if it's not a dispensary. Because you can have a collective like in your house or something, I think.
Right. Well, so, for example, I guess someone could live within the city of Santa Barbara and be part of a collective, but the collective grow where everyone goes out and tends the marijuana. That may actually be in the county.
Okay, so you could be a collective. So the collectives then would be kind of then limited to collectives where it crosses like city lines. So if you're in the city, you'd have to be part of a collective that was outside the city, basically, to get the benefit of being a collective.
This ordinance only specifically regulates where the cultivation can occur within the city and how it can occur. So you could have 4 people that are part of a collective that live in Santa Barbara. They just can't collectively cultivate their marijuana here. They can go cultivate it in the county if the county lets them do it, and ingest it, I suppose, in the city, but you just can't collectively engage in the cultivation.
Okay, it's just,
here.
I guess it just, maybe I'd need to do some more reading because I just don't get what else a collective does then. I thought that's mainly what they did. That's the main thing. Why be a part of a collective? Because you have to pay dues or something, probably.
Right. Well, they can still be a member of a marijuana storefront dispensary,
Right.
and go in and not have an obligation to cultivate that. Their in-kind contribution would be monetary, most likely.
It'd be a larger, not a small collective, but a larger collective, right? Okay, then this is kind of related in a way, but I have a couple of questions about delivery. I know we're not addressing it here, and I completely understand and get it, and makes total sense to me that this is not something we need to address right now because we're on a deadline particularly. And that makes total sense to me. But because it comes up as one of the features, there's something I don't get about the delivery. So AB 266, at least your bullet point, I know it's obviously paraphrased, but it says mobile delivery by permitted dispensaries if we don't limit it locally. So I understand that part. But is it also mobile delivery to dispensaries and from dispensaries? Does it go both ways? Or are you talking about, because it's a zoning provision, oftentimes, whether it's a dispensary or maybe another kind of business, we might say, oh, because of traffic impacts or nuisance or whatever, we don't want deliveries from that site, pizza delivery, or I don't know what it would be. But when you're saying the law says mobile delivery by permitted dispensaries, is it also talking about, say Ventura County allows cultivation on a larger scale? Does this law, and I don't know how it affects our current ordinance, that's the other question, does it allow a delivery from Ventura County of, I don't know what the amount would be, but something that started out more than 100 square feet in Ventura County? Does it allow that delivery to the dispensary?
Yeah, I understand now where your confusion is. When it speaks to, when AB 260 speaks to mobile delivery, it's only referring to specifically the delivery of marijuana from a dispensary to a qualified patient. So the person would have to call up and say, I want my medical marijuana, and then it would be delivered. The AB 266 specifically carves out a separate definition for transportation.
Okay.
And it's that transportation licensing requirement that gets the marijuana from a growing facility to a manufacturer or to a distributor.
Okay, that helps a lot, because so what you mean by this is the personal delivery.
Right.
From a dispensary, but still they can get their deliveries from somewhere, because that's what the part is like, well, how do they get their product to the dispensary if they can't? Yeah.
Right, they can get the product there. It's just once it's there, it's kind of like, I hate to say it, like a pizza delivery thing. You call up and then...
Got it. Okay.
The driver drives it over to your house.
Okay, thank you. And maybe at the end, I don't know, maybe somebody else is going to ask this, but I'd also just like a quick rebrief of the schedule we're on for this. Sure. Thanks.
Okay, Commissioner Lodge.
Thank you, Mr.
Questions?
Chair. I have two questions. What if someone wanted to grow their marijuana in pots? Would it then be limited to, they couldn't occupy more than the 100 square feet, I assume?
Correct.
With the pots.
Correct, Commissioner Lodge. I guess they could put the pots really close together.
Yeah.
Pots in pot.
Yes. Growing pot in pots. Yeah. Well, I can see people living in apartments with a little balcony,
right.
Something like that, and not having a garden area as such that might want to do that. And what if a qualified patient is physically handicapped and can't manage the cultivation? Are they just out of luck?
And then they could purchase their marijuana from a dispensary.
Okay, they just wouldn't be able to cultivate it themselves.
If they were physically unable to, correct.
Okay.
They could not have someone cultivate it for them.
Okay, thank you.
Commissioner Jordan, questions?
Thank you, Mr. Chair. So I have many of the same questions, but maybe just off on a tangent. And the first one is that disconnect between what the caregiver can do, I think, according to state law, and what we're saying they can't do locally. And I guess why are we making that distinction? Why are we not allowing a designated caregiver for a patient to do their 100 square feet?
The council just specifically wanted to limit it to qualified patients for personal use.
Okay. That's pretty clear. So, and then, I'm looking, are you the subject matter expert on this right now?
One of them.
Okay, I'm so sorry to hear that. So, Google just brings me right back to being dangerous. But so I was looking at the license types, and I was just wondering if this is kind of off on a tangent, but if you could help me correlate the license types versus the distribution line of a product from when it's produced to when it gets to a dispensary, because I see a bunch of different cultivation things, which I assume, just like type 1 and type 2 would be us. And then, as you mentioned before, I see a transportation license, but I'm not sure if the transportation license is from a personal cultivator to a dispensary, or if it also has, or if a personal transportator also has to go through the distribution and the lab testing part, and then back to distribution, and then to a dispensary. How does that whole process work? If I'm growing these at home in my backyard, then what happens after that point?
Okay. So, by the way, I had to make a chart to figure out all the licensing categories and requirements because it was very confusing. But if you're growing it for your own personal use, that's not what you need a license for.
Because you're exempt under that square footage, right?
Square footage, and assuming you weren't in the city of Santa Barbara, who wants to impose this land use requirement, and you were in a city that didn't, you'd still be subject to the health and safety code, which would allow you to cultivate up to 100 square feet for your own personal use. What this piece of legislation, the Medical Marijuana Regulation and Safety Act, is really driving at and trying to clarify is medical marijuana being used and sold through dispensaries. So it's contemplating more of and really what it does is it's contemplating a commercial use now of marijuana. It's no longer under this new legislation. You don't have to operate a not-for-profit dispensary. You can sell it and make profit.
When you hear about, in years past, I've heard like up in Oakland, they're going to have 100,000 square foot warehouse, commercial operation for process. That's really where that's targeting.
Exactly.
Okay. And so then I grow it at home. I got my crop. I'm ready to take it to my dispensary / collective that I belong to. I also don't need any of these other licenses to have it tested or to transport it there. I can legally in the city and in the state take it there.
Within the city, you would not be allowed to, under the proposed ordinance, you would not be allowed to take it to a storefront dispensary because you are only allowed to grow it for your own personal use. If you took it to the dispensary, you'd be giving it away for someone else's use.
Okay. And so then a dispensary then must be getting their product from outside the city.
Correct.
Okay. No other choice.
No other choice.
Okay. This is where you start to need that chart, right? Yeah. And then last question is I don't really understand this 100 square foot horizontal plane. Does that mean literally I just have a 10 by 10 block on the ground, one plane, and I can't stack my grow panels above that? Is that what you're saying?
That's creative. It had been drafted, and the intent was not to concern ourselves with the height of a plant,
Right.
but how many plants are within 1 square foot.
Okay.
So I suppose technically you could.
And I don't have any experience on how high plants get, but I guess
I've-
what I'm saying is if you have a garage that has 15-foot high ceilings and your plants only get 3 feet tall, can you have 5 levels of plant stock in that 100 square feet? Okay, I like that answer. That's a good answer.
City attorney says no.
And then I had one other question. I can't remember it, but it may come back to me. But I may think of it. Thank you, Mr. Chair.
Okay, Commissioner Campanella.
Thank you. Question, how was the 100 square feet arrived at?
I think council arrived at that because that's what's now permitted under the Health and Safety Code. A qualified patient can cultivate 100 square feet.
Okay. And then we don't assume that under the personal use ordinance that we're not going to be in conflict with the state ordinance or the state law, which is going to be, let's say, more liberal. I don't want to use the word liberal, but you're allowed to have more and you're allowed to have it in various spots. But we would, by this ordinance, be able to stand alone and not be in conflict with whatever the state regulations allow.
Correct, Commissioner Campanella. The state has even said that if you have an ordinance in place that completely bans cultivation, even for personal use, that's fine. If you don't have an ordinance, then you're subject to state licensing.
Thank you. Now, we talk about dual licensing. Now, of course, if we were to ban something, there would just, it would be banned. But let's say we have our own ordinance. Is the license then that we have is the same one that the state issues, the same form?
No, it's different, and this is not for the dual licensing doesn't take into account cultivation. It's more on the dispensary level.
Okay.
And it's the city's more restrictive ordinance would prevail over state.
Okay. And let's see, looking forward, I know we don't have the transportation and distribution on our agenda, but in looking at this current ordinance for cultivation, personal, or how people have to get it to themselves if they can't cultivate or they're not in condition to cultivate.
Right.
Are we looking forward a little bit into what the transportation ordinance that we might consider would look like to make sure that it dovetails and facilitates their, let's say, helps dovetail in with what we're coming up for the current ordinance on personal cultivation?
If that was something we wanted to regulate, we could look to that. The way that the current storefront dispensary is written, it requires collective cultivation, so the dispensary would have to itself, I guess, obtain a state license for transportation to get it from its collective grow location to its dispensary.
Okay, well, we've had a number of questions from other commissioners. I guess mine is, given if this goes into effect for personal only, that people who are not personally growing it still would be able to have access to it, because we don't anticipate a very restrictive transportation and delivery ordinance in the future.
I see what you're saying. Yeah, no, so it doesn't, it's not requiring licensees for, say, individuals that are taking it from the dispensary to their home. It's only requiring licenses for people that are taking, say, you're growing marijuana in Ventura and you need to get it to a dispensary in Santa Barbara. That's what it's contemplating, commercial transportation. Anything regarding personal uses.
Okay, so we're not going to cut deliveries off at the border, which means you can't get anything. I mean, you're looking at being able to allow, given the ordinance we're discussing today, it will be able. There are other sources that can get into the city to people when you come to look at the transportation and delivery ordinance.
Right. Well, it doesn't speak to the mobile delivery is separate from transportation.
Okay.
So if the city at some point chooses to regulate mobile delivery, which means delivery by a dispensary to a member,
Okay.
It can do that. It could create an ordinance that says we don't want any mobile delivery in our city, or it could create an ordinance that says we only want mobile delivery from city permitted dispensaries, which would prevent state licensed dispensaries that may exist in Ventura from coming into the city to deliver to members in Santa Barbara.
Okay, so there's thoughts going on what possible alternatives there may be when you reach that point of
Yes.
delivery. Okay, and do we know approximately how many people are actually growing marijuana for their own use now in the city?
I don't know.
Idea? how prevalent that might be. Okay, all right, thank you.
Thank you. Commissioner Jordan, you remembered your other question. You want another bite at the apple here?
Actually, as soon as John started talking. So, one of the foundations in the ordinance language is the equating of the 100 square feet to environmental concerns and noxious behavior or whatever. So what is 100 square? How do we get that number other than piggybacking on some of the other uses of 100 square feet at the state level? Maybe like what does 100 square feet produce a year in pounds, and how do we say that 100 square feet is the line where it becomes a community issue versus 150 square feet or 200 square feet?
I don't know that council specifically considered that. They were looking more towards, finding some sort of guiding
Just kind of
line.
grab that 100 square feet because it was used elsewhere, right?
That's my understanding. And,
Okay.
I think what 100 square feet of marijuana produces, I guess, would depend on the size of the plant. I don't know.
And I guess that's, again, part of my, question on that foundation is that you set up the foundation that's the threshold where after that point it becomes a community concern, but you don't know, there's really no basis to that. But, okay, thank you.
To speak to that, Commissioner Jordan, I suppose that's where the public nuisance provision would come into play if you had, 100 square feet of, I don't know how tall they get, but maybe 16-foot high marijuana plants, and there was some criminal activity going on because of the size, or it was,
Maybe you want to cover the use of fertilizer to make the plants bigger. Put that in there too. Huh? Okay, Commissioner Schwartz.
Thank you, Mr. Chair. I think I'll start with page 1 on our staff report. Under background in the second paragraph, there's a reference to regulating, quote, the type and scope of cultivation. So I was wondering, Ms. Ostranger, if there's any interpretation of type that would be helpful to us in terms of our read of the proposed ordinance language and our recommendation to council.
I'm sorry, could you direct me again?
Oh,
to the
yes, this
paragraph?
is page 1 of our staff report under the section entitled Background. And in the second paragraph, in the first sentence, towards the end of that sentence, City Attorney to draft a zoning ordinance regulating the type and scope of cultivation. So type of scope, I think we've been talking about. The type of cultivation, how would that be defined for our considerations today, or my read of the word type?
When I drafted it, I intended type to refer to either whether it would be exclusively for personal use or commercial use or
Okay.
collective cultivation.
I see, okay. So that leads me to a question I'm not sure I quite heard any of my colleagues asking that I was interested in. This reference to personal versus commercial, some of the documents we have are somewhat confusing to me about personal versus commercial. I think I'll go to the draft ordinance language. So this is Exhibit B in our package. In Section C, this is the third paragraph, Section C, Section 1, Paragraph C, there's a reference to environmental impacts and negative health and safety impacts associated with commercial cultivation and personal cultivation. So I don't know why we're referring to both commercial and personal vis-a-vis this ordinance amendment and the 100 horizontal square feet allowance, considered allowance for cultivation. So why are we saying commercial and personal if we're saying it's only for personal use?
Well, I think,
Am I not understanding?
Go ahead and do that one.
Thank you, David. Commissioner Schwartz, the ordinance does regulate commercial cultivation by prohibiting it. So the reference to commercial cultivation and personal cultivation of more than 100 square feet was intended to address Commissioner Jordan's concern about a threshold beyond which the cultivation of cannabis becomes noxious. And the finding there is actually parroting the language in 2887-030C of the code, which is a section that allows for prohibiting uses that are obnoxious and detrimental to the welfare of the community. So it's a legislative finding. Typically, legislative findings are not required to have a substantial evidence-based factual support. They are the legislative wisdom of the Planning Commission and City Council, and as a function of separation of powers, courts generally will not substitute their judgment for yours in drawing the line at 100 feet or drawing the line against commercial cultivation.
Okay. While I'm on that sentence, though, let me ask you, Ms. Ostranger, would it be helpful, and to my colleagues, the description of the reference to 100 horizontal square feet, in some of our documents, the word horizontal exists, and in some cases it doesn't. So I'm wondering if we should be consistent, because horizontal, that implies a very specific way of cultivating, spatially of cultivating. And so, for example, right here in the ordinance, in this section, the word horizontal doesn't appear, and yet in the following page of the draft ordinance, B, under definitions A, and then it says, and then B, qualified patient, and then it goes on to talk about personal medical use on a single cultivation site existing in a horizontal plane. So I would just, I'll convert my question to a suggestion, and that is perhaps you could go through all of our documents that you might forward to council, and I think for consistency and for clarity, it's important regarding this, if horizontal is important to the council, then that be referenced in all of the germane documents. But I'm going to still stay with the ordinance for a moment. So I appreciated, Mr. Colon, your explanation. Back up in paragraph A of our ordinance, so I had been referring to C, back up in A, it's now only referring to commercial medical cannabis activities. Section B, licensed commercial cultivation. So I don't know, I can let it go in terms of my somewhat confusion about what we're regulating versus commercial versus personal. And if you're saying it doesn't matter, it's commercial or personal, then I'll leave it to you to clarify and with council. But this kind of back and forth, and with some sections it only references commercial, in this other section commercial and personal, provides a little bit of a confusion to me in my read of what's allowed and what's disallowed in the way of cultivation. Okay. I'm back on still page 1 now of the staff report regarding the 100 horizontal square feet. Does this need to be contiguous? Because I didn't see any language that would describe between indoor and outdoor, which is also part of the allowance that I've seen here in our documents. So you could have some indoor space that's, let's say, 50 horizontal square feet and outdoor space of 50. Do we have any concerns or interest in further describing the full 100 square feet? Because it doesn't reference contiguous. And we have allowance for indoor and outdoor, according to what we've received today.
Commissioner Schwartz, the ordinance itself refers to a single cultivation site and then cross-references the state law's definition of cultivation site. Okay. So we would assume it's 100 contiguous square feet. If you wanted to recommend adding that language, it would be perfectly appropriate. Okay,
I think that would be helpful. I'll just say it now while I'm thinking about it, because I'm not sure that, the average person reading this, and let's say it's an applicant for a dispensary or a patient looking to cultivate, would clearly understand that as to what single cultivation site means. So I think clarity is helpful here. Okay, let me keep going. Regarding the possible consideration of this being an agricultural activity, is there any further discussion that would be helpful for us to have? I mentioned this to you before our hearing today. On page 2 of our staff report, under discussion, section B, this is MRSA's impact on the city, you mention here, or staff does, that since the cultivation of marijuana could be considered an agricultural activity, and then it goes on to talk about some other things, possession, use, distribution. I'm not sure what to make of the fact that it could be considered, and does that change anything in terms of our zoning allowance for cultivation? Because we don't allow agricultural product cultivation in all of our zones. So, am I?
Commissioner Schwartz?
Yes.
With respect to agriculture, it's, I think it would be found in D of the ordinance.
Okay, I'll go there.
That's where it's,
All other cannabis cultivation prohibited?
right.
So,
And it shall not be construed or permitted as agricultural or other use in any zone.
so am I understanding this is sort of a carve-out? In other words, we're saying somebody may consider this agricultural, but we're saying for this purpose, it's not going to be deemed agricultural, and therefore the cultivation can occur in zones where otherwise other agricultural cultivation would be prohibited?
That's correct, Commissioner Schwartz. But in addition, what we're trying to do is unring any bell that may have been rung that equated medical marijuana with agricultural use in our existing law.
I see.
And that's why the staff report hedges its bets by saying could be considered.
I see. Okay, thank you. Ms. Ostringer, also before our hearing, I mentioned to you that I was going to ask you to comment on, I could say why, or the pros and cons of why we would not want to contemplate at this time all of the regulatory aspects under these 3 new pieces of legislation and only cultivation. I know we have some time, but I'm wondering, is there an advantage to piecemealing it other than needing cultivation to be handled by March 1 of next year? Is that the only reason that we're not dealing with, for example, transportation, testing, sale, and dispensary operations, which is elsewhere in our documents?
Yes, Commissioner Schwartz, this really is being driven because of the urgency of getting this ordinance or the cultivation aspect of this passed by March 1st.
Okay.
The last possible date we could get this to council and still meet that March 1st deadline, I believe, is January 19th.
Yeah.
So rather than try and contemplate this is a rather large piece of legislation.
Yes.
We wanted to make sure that the city had at least the ability to retain control over cultivation.
So then would it be City Attorney Office intention to come back through Council and Planning Commission on these other aspects that the legislation directs us to consider? Again, manufacture, dispensary operations, distribution, and I don't know if we're involved in testing. I guess that's at the state level. But clearly a number of other aspects, and this is referenced in the November 10th memo that you sent to Council. So what are your thoughts about queuing those up for the city to consider?
Well, I certainly think with respect to mobile delivery, since we don't presently have any ordinance on the books pertaining to that, it would be a good idea to get in front of council, if council so desires, to regulate that before January of 2018 when the state's going to regulate it. So if council directs us that they have any desire, or the Planning Commission, to consider these issues, then we certainly will.
Okay. Then regarding this new legislation, or these new 3 pieces of legislation, has there been any new discussions with the Santa Barbara Police Department regarding a change in their position on enforcement, on review of operations and enforcement?
I haven't had that discussion.
Especially the operational plans has been something that we've been told our police department is not inclined to review and approve, let's say.
The Commissioner Schwartz, as I understand it, the police department has expressed a concern that under federal law they might be viewed as some sort of accessory to an illegal act by reviewing those plans. Without challenging that conclusion, we've advised that the operational plans could go forward without direct police review. We're not planning to raise that question again until there's clarification at the federal level. Right now, as I understand the federal law, there has been a defunding of enforcement activities related to marijuana. That doesn't change the police department's concern.
So once our new ordinance goes into effect, and let's say any subsequent ordinances that deal with these other aspects, delivery and so forth, transportation delivery, if there are any violations or alleged violations, then we need to go out and look at compliance, and if there's enforcement that's required, then is our police department, have they committed to following through on enforcement of any new ordinances, at least that we enact locally, whether or not the feds view it as legitimate, acceptable, et cetera?
Commissioner Schwartz, for the purposes of this ordinance, we were more concerned with whether our code enforcement staff would enforce it. They will likely be the first enforcers.
Yes, I see. Okay. Okay, I think I just have a couple more here. I think lastly, I wanted to ask you, Ms. Ostringer, this goes back to the effects of land on land use, environmental, not really public nuisance, but public health and welfare. And I'm usually very clear about why staff is finding something to be CEQA exempt, but it seems to me that I'd like your thoughts back again. This is now on page 2 of our staff report in finding this exempt from CEQA consideration. Can you talk to me a little bit about why this type of otherwise agricultural product cultivation, but we're not calling it agricultural product cultivation, in homes, in residential structures, would not rise to the level of being considered a significant effect on the environment, change of land use, and so forth?
Commissioner Schwartz, of course, the Planning Commission could go in a different direction. The analysis that we used was based on a baseline assumption that there is existing cultivation going on and that it's permitted. So this ordinance is a restriction cutting back and by definition wouldn't have the potential for creating new significant effects. It has only the potential for reducing significant effects. So we felt it met the terms of the 15305 exemption and didn't meet any of the exceptions to the exemptions.
So lastly, regarding that, if, as has happened, there have been significant issues with some growing sites, there could be fires. There can be a variety, explosions, fires. I mean, we've seen it here in the city and elsewhere, of course. What action is appropriate or can we take legally with such a new ordinance amendment if, in fact, it's creating that level of danger, if there's such an occurrence? And it's beyond public nuisance. I mean, if there's multi-unit family complex and one of the apartments is lit up on fire because of cultivation or irresponsible cultivation practices, what action can we take?
Well,
can we revoke their cultivation privileges in a sense, or because it's not really? I don't know, how do we do that?
Commissioner Schwartz, the state will only preempt our right to regulate if we don't have an ordinance in place by March 1st of 2016. So if we have this ordinance in place and we've demonstrated our intent to regulate the cultivation of marijuana, there's nothing to say that if we find that this isn't the right fit for Santa Barbara and we want to scale it back or we want to modify it, that we couldn't bring this back and amend it at some later time.
But we can't handle it on an individual basis, is what I'm hearing from you.
That's not correct, Commissioner Schwartz. That's why we have the nuisance carve out.
Oh, we could then, you're saying affirmative.
Right, it would require a nuisance action by my office to deal with the situation.
I see, okay.
And I could envision, as you alluded to, the biggest concern will be a multifamily setup where there are many hundreds of square feet of cultivation with electricity and all of that.
Right.
And as Ms. Ostringer said, we'll cross that bridge when we come to it.
Yes, okay. Thank you very much. Thank you.
Thank you. Commissioner Higgins, any
Yes.
questions?
Quickly, for the subject matter expert, how do you get into the difference between the cultivation? I assume is just the growing, and then you have to somehow dry and package, and that all has to happen within 100 feet, or that's not cultivation. And my question was actually related to Commissioner Schwartz with regard to enforcement. Do the enforcement staff, are they going to be educated on whatever your answer is? And I guess tangentially is if they do need to enforce on somebody or at least investigate a potential nuisance, and as it relates to Mr. Cologne's response with regard to police involvement, can enforcement staff typically just call for law enforcement backup on any other kind of nuisance, and will the city police department refuse to come out to an enforcement action or nuisance claim in that regard? Sorry, I just gave you a mouthful, but maybe start me off in the right direction with what else can happen within 100 square feet, or is that the whole operation needs to be within 100 feet?
Okay. With respect to that, the personal cultivation would then, it doesn't speak to, that's just for personal cultivation. It wouldn't trigger any state legislation licensing requirements. So if you want to cultivate at your house and then I suppose take it over to your friend's house to do what you do with it to make it ingestible, you can still do that. Does that answer your question?
So the 100 square feet of cultivation is the growing of the plant.
Correct, Commissioner Higgins. Specifically
And we're not getting into
refers to-
other square footage requirements for how else do you make it ingestible.
That's correct. With respect to your other question regarding enforcement, like Mr. Cologne said, it would most typically be handled as a code enforcement action. And our general code enforcement actions, we have zoning staff that goes out if there's a complaint or if they notice something, and then they can issue an administrative citation. If it's to such an extent that it's a public nuisance that we couldn't wait for the issuance of an administrative citation, or our office would bring a civil suit to get an injunction and shut it down. We don't necessarily need the police to go out there and cite it. Our office can immediately file a civil action for an injunction to have the grow closed.
Satisfied? Okay. Commissioner Peugeot, you had another question?
I have a couple follow-up questions. Thank you. My questions pretty much all come up on what's unnumbered, but the second page of the ordinance. Okay, first I just want to nail this thing in my mind about cultivation site. I do see that in section B of that page, it talks about a single cultivation site. So that tells me it's not 100 square feet of cultivation. It is the site needs to be 100 square feet. That's the way I read that, and it kind of makes sense to me if that's correct. So you have this one site, and just to clarify, you have a site, maybe it's 10 by 10, maybe another configuration, but it's one single measurable area, which I probably am guessing makes sense just because you can measure it, and it's a little clearer to determine whether they're complying with the ordinance or not. But a cultivation site, first of all, refers back to the California Business and Professions Code section that you cite above under definitions. So is there any more clarity for us? If I didn't actually read that section. Does that section actually clarify any more details, some of these questions that have come up today, like if you have a single site, so you have Bender board or something around a 10 by 10 square foot area out in your garden, instead of planting tomatoes, you fill it up with marijuana plants because you have a medical need. Right now, if I have my tomato plants and the tomatoes fall over outside of that confined garden space, it's still a confined garden space. So is that kind of what you're thinking? It would be like that, or do you have to actually measure the umbrella of the plants as they get larger? The reason I ask this is, well, first of all, there's going to be a lot of questions about this ordinance, I think is important to know. Secondly, a lot of times, maybe not so much, say, in the tomato example, but say you're planting basil or something. You put little tiny juvenile plants so that they're mature by the time that the other ones expire. So I don't know how much a person maximum needs if they have a medical marijuana need. I don't know if that relates at all, but say it does. There would be a need, I would suppose, to start little plants, seedlings up while the other plants are growing. So does this state law, or do you see how this would handle that? I mean, can you not have them in little grow pods in a separate place because they're seedlings? They have to be inside that same 100 square foot area. And if the plants are large and falling over, is that more than 100 square feet? That's one question.
I think the cultivation site, it's a plane of 100 horizontal square feet. So, and as Commissioner Schwartz has indicated, she'd like to clarify it as a contiguous space. So you could cultivate as many plants as you could get in 100 square feet, but that doesn't mean to say that you have to use all of your 100 square feet. If you had 3 plants that took up 100 square feet, that's all you needed.
But it's the boundaries of the grow area. It's not what the plants do inside the grow area.
I assumed it to be the entire aspect of the plant, or that's how.
Because as they grow, they get bigger, so maybe you can only plant 70 square feet because they get big. I mean, my tomato plants get, 3-4 feet tall. They slop over all over the place when they're mature. Just kind of questioning, because those things will probably come up. I think that could be slightly clarified. And then my other follow-up question, I was hoping maybe the business code, the business and professions code, might clarify some of that. But, okay, I'm back to this aspect still as a follow-up on that. We've got definitions now creeping in that I don't remember before. So we've got personal medical use. That one I think is totally clear. We've got the idea of a collective that goes back to the old original laws, which I always thought had to be nonprofit because you're not making a profit off of them. You're basically, even if it's a dispensary, you're grouping people together like a club, and I believe it has to be nonprofit. So how is that now commercial? I don't get that part.
The new legislation will do away with the requirement of nonprofit. So you could, it now is allowing the commercial, it's creating a commercial enterprise through medical marijuana.
So we have one approved, but I don't think occupied yet, dispensary. We have a couple other lining up. So when this law takes into place, I mean, those were approved under that existing law. I'm venturing here, so help me if I'm going very far astray. But that law was under current regulations, which basically says a dispensary can be a collective, and a collective has to be nonprofit. Now, all of a sudden, in January, those dispensaries, do they keep following the old law, or now they can be commercial and they don't have to be nonprofit? Is that what you're...
Commissioner Peugeot, no, under this dual licensing scheme, the city's ordinance is the one that's going to control. So our more restrictive requirements that they be not-for-profit is still going to control. The state may say you don't have to, but because our ordinance and to get a permit under our ordinance says you do, that's the ordinance that they're going to follow. The more restrictive local provisions will prevail.
Commissioner Peugeot, to the first part of your question, Section D of the ordinance is intended to provide the belt and suspenders that says anything we didn't permit by way of personal medical use is prohibited. So if there is a ambiguity between commercial and nonprofit use, it's picked up by D, and a nonprofit use would not be permitted. Does that make sense?
You mean a for-profit use?
Either.
Oh, okay, yeah, okay, I get that. I'll accept it. It's kind of confusing in reading and understanding, so I hope there's some good handouts. And I have just something I want to throw out there as a concern. Let me just say, I'll be supporting the ordinance. I think the approach in making it narrow so that we can deal with what's immediately in front of us is very important. And as I know that was brought up at the council meeting, to do it through some urgency version it sounds risky. And so this makes sense to me. And then come back and address things later. And it looks like the law will be discussed again at the state level within the next couple of years. So I think we're really doing our best job to catch up with the provisions as we need to. So I agree with the process we're using. I have, and perhaps this is something that can be addressed later if it comes back, but I have this gnawing concern from not an ordinance standpoint, but from taking a step back and looking at the bigger picture kind of concept. To me, it's uncomfortable when we say we are going to allow some of these uses like dispensaries, but you can't grow it in our town. You have to grow it in somebody else's town. And for example, if the county and the other jurisdictions all do the same thing, then basically you're allowing dispensaries that have no source for their product because it would be, well, I don't know where they ship it in from Long Beach or something, I don't know. But I mean, that to me seems pretty unreasonable of an idea. So I think that at some point we need to revisit this cultivation part, maybe when the state law becomes more clear, I'm not sure. But I have this gnawing concern about that part of it. It's not exactly regional cooperation, for one thing. So I'll be supporting the ordinance, and I think it's as good enough for what we need to do right now. But I do have those kind of, like I said, little gnawing back of my mind concerns.
Commissioner Jordan, you have another question?
Of course. Thank you, Mr. Chair. So as much as I follow this, it's like I had to beat myself up over it just to understand it. It's really to June's last point. So right now, if we had a dispensary open, and without this ordinance that we're looking at, a dispensary, a collective member within the city limits that's part of the dispensary could grow crop and contribute it to the dispensary for sale.
No.
No?
No,
It's actually prohibited in our dispensary?
It would be prohibited under this proposed ordinance.
No, but no, forget the proposed ordinance. I'm saying right now if we had a dispensary open, the source of the dispensary crop could come from personal cultivation within the city limits.
Yes.
Okay. So I think that's whether by on purpose or oversight, I think that's a glaring omission from the staff report on a change in boats on this. And I'm saying that from like almost supporting what you want to do, but just saying I don't like the fact that didn't just jump out, and it took me an hour of listening and looking and going back and reading 2880 right now to figure that out. And my question would be that as a community member, and as that supply line, as June said, got farther and farther away, if adjoining cities did the same thing, why do I want a guy in a car with a trunk full of 100 pounds of marijuana driving into our city to supply a dispensary rather than 50 people that are members of the city within the city limits giving 8 ounces to the dispensary? It's kind of a theoretical question. To me, I think, only having today to realize that, I think I'm personally more comfortable with the source being within our city limits for members of a collective at a dispensary rather than starting to push this bubble of supply out further and further away from us. And I'm, that to me right now is I've been sitting here reading 2880 and trying to figure out if that's really what that meant, and June was going in the same direction too, and it's clear what that means. But that to me is, if that's what City Council meant, great, they get the final word. To me, I'm very uncomfortable with that. I'm uncomfortable with dispensaries per se to begin with, but the casual, homegrown community base of the source and engagement of that dispensary, to me, is a much more palatable dynamic than the thought of a guy driving up from L.A. or Riverside with 100 or 200 pounds of marijuana in his trunk into our city on a monthly basis. So I know you're not. I know you're just telling me that's the way we're presenting it. So I think if we get to comments or recommendations, that's going to be a line in the sand for me. But I think the staff report should have clearly pointed out that we were changing boats there. That the dispensary arrangement up till now was this, and once this ordinance goes into place, it will drastically change the supply line for the dispensaries as we've agreed to them up to this point. Thank you, Mr. Chair.
Commissioner Lodge, question?
Comment on
Well,
what Commissioner
we'll get to comments here.
Well,
Okay, go ahead.
okay. Well, if you'd rather I wait.
Go ahead.
From reading this draft ordinance, it seems the council very clearly did not want commercial growing of marijuana in the city. And so, I'm sorry. It seems as if the council clearly in this draft didn't want any kind of commercial cultivation of marijuana. They only wanted it for individual use. And if you start allowing everybody to distribute it to the dispensaries, it becomes a commercial operation, it seems to me. And I don't know that it's any better or any worse than they're buying their supplies outside the city. Thank you.
Commissioner Campanella, question?
Yeah, just follow up. The definition that we're working with in the ordinance of commercial is from our zoning ordinance, which states commercial means managed on a business basis for profit. Okay. So we're not allowing that as part of this ordinance as far as cultivation. But following up on Commissioner Jordan's comment, the nonprofit isn't addressed.
I think that would be addressed under Section D, which is kind of the catch-all, and
I'm sorry?
it would be, let's see, Section D of the proposed ordinance, to the extent expressly permitted by this section, cannabis cultivation of any kind and for any purposes shall not be construed as a permitted use. And then it also specifically defines personal use to mean non-commercial cannabis cultivation.
In addition, Commissioner Campanella, Section E is a cross-reference back to the state law. The state law uses a confusing term, permissive zoning, to mean zoning ordinances where only what is expressly permitted is allowed, so that if, for example, marijuana isn't called out specifically, it wouldn't be allowed. Section E here is saying that except where you've expressly permitted marijuana cultivation, cannabis cultivation, it's prohibited. So that would cover, as would D, the not-for-profit or collective component.
Well, let me ask this question. And this is a proposed ordinance, and an ordinance needs a 5-2 supermajority. But within this ordinance, we're effectively changing another ordinance, which is on dispensaries, without really looking I'm assuming by making this change, that ordinance is affected without really a public hearing on that ordinance itself, the dispensary ordinance that we currently have. Isn't that correct?
Well, I don't believe that's correct. There's nothing in the dispensary ordinance that compels or requires cultivation within the city of Santa Barbara.
I'm talking about the nonprofit cooperative aspect. Is that in the dispensary office?
As Ms. Ostranger said, a cooperative could still exist. It simply couldn't have grow sites within the city. So we're not conflicting with that ordinance. We're narrowing the application of it. I accept and appreciate Commissioner Jordan's criticism of the staff report. We'll make sure we ventilate that issue with the City Council when we come back, namely the impact on the dispensary ordinance. But I also have to say that Commissioner Lodge's comment is correct. The City Council was very specific about personal medical use only and not wanting to support collective arrangements.
Well, what I would suggest, and a concern I have, is we don't know how many people are personally cultivating it, let's say. But there are physically people who maybe need it but can't cultivate it. And maybe their option versus hauling things in from elsewhere is the cooperative. The nonprofit cooperative, which is currently allowed. So I guess my question is, I understand what we're saying, but why are we eliminating that capability?
Our answer to the City Council, Commissioner Campanella, was that the patient who can't cultivate would still be able to access a dispensary. The missing piece there that's been pointed out by the Commission is the delivery component that we're not addressing yet. So my suggestion would be that as a matter of policy, the Planning Commission consider whether delivery should be permitted only from, as Ms. Ostranger said, only from dispensaries within the city, or whether you're going to allow delivery from without the city.
Well, I don't know. I guess I wish I could think of all the chart, if you will, but a different type chart as far as getting the product for ingestion by the people that really need it, and are we sort of limiting that capability? I guess I'll just say that's my concern. And I know what happened at City Council, but I don't know if the dispensary nonprofit growing as a collective was addressed. I wasn't at the meeting where I saw it. I don't know if that specifically was said, no, even that we don't want to do. Or is it by just coming up with one thing that is included, the cooperative not-for-profit was not considered in the discussion.
I don't recall it being specifically addressed either, but that's why you're here. Yeah. If the Commission wishes to forward a recommendation for a modification with respect to collectives, that would be within your purview.
Thank you.
Commissioner Schwartz, another question?
Two questions. Is the city attorney's office then opening the door for and possibly, I'm going to say, encouraging us, if there's an interest, a majority interest among the commissioners, to discuss and make a recommendation on delivery options? I didn't think that door was open when we started the hearing today, so but now I'm not certain about that.
My response to Commissioner Campanella was to say that the Commission could consider that policy. I wasn't suggesting you do that now. I don't think that's in front of you. So in the future, if we either come forward with it, which we will, as you know, we came forward to the City Council with both the cultivation and the delivery issue, but the council chose to defer action on the delivery issue.
Right, I heard that.
So that's an open policy question. You could schedule time to talk about that, or you could wait for us to come back and then address it.
So my second question, and this is follow-on to Commissioner Campanella's, regarding perhaps the oversight unknowing oversight by the council and not taking up, and with staff not taking up this issue of the nonprofit collectives and the impact of that with the ordinance amendment. What I thought I heard you say, but please correct me if I'm wrong, that the commission could forward a recommendation that that be taken up by your office, staff, and the council when this goes back to council, so that we're not, without careful consideration, eliminating that from being allowed?
That's exactly what I said.
That is exactly what you said. Okay, so to my colleagues, we can take that up today and make that recommendation to council when it goes back. Okay. Lastly, Ms. Ostranger, I was wondering if you might consider, in terms of, again, clarifying and creating more consistency with our language in the draft ordinance, this reference to indoor or outdoor cannabis cultivation, and with respect to the 100 horizontal square feet, might you also consider, and to my colleagues as well, clarifying that the indoor is a discrete 100 horizontal square foot space, or, and you have the word or, it's not and or outdoor cultivation space, again, at a maximum of 100 horizontal square feet contiguous space. So again, we're clear and consistent in exactly what the spatial cultivation allowances are throughout the ordinance. Would you be comfortable considering that with the city attorney's office, considering that throughout the draft ordinance?
That's something that the Planning Commission.
Okay, well,
wants.
I'll ask my colleagues if they would please consider that and comment on that. I think, and perhaps Commissioner Peugeot mentioned this a couple of times, to the extent that we can make clear and consistent and really tight language around all this, I think is going to save us all a lot in the long run, because otherwise, if there are any holes or loose language, I think we're going to find ourselves in an even greater enforcement scenario than we might otherwise. So I'll leave it at that. Thank you.
Commissioner Peugeot, you have further questions?
Actually, no, it's more of a comment, so if I can wait to the comment section.
Well, if there are no further questions, then you might as well go ahead and start comments.
Would you like me to start that? Okay. All right. As I mentioned earlier, I will be supporting the ordinance and the approach to the ordinance. We need to take this in a step-by-step basis because the law is fluctuating and the whole industry of medical marijuana and commercial marijuana is also evolving rapidly. So I think taking little bites of the apple is a good thing. So I will be supporting that. As to two items I would like to make comment on. One is the conversation that was ensuing about, I think Commissioner Campanella brought it up, and it's been alluded to in some of my questions earlier about commercial, non-commercial, the existing ordinance, et cetera. What I see as an expedient method of not unintentionally harming those who have the inability to have their own 100 square foot plot or to actually do the work or labor in the growing of it, which I believe was the initial intent of the small collectives that I think go up to like 5 people and you can have it in your house or something. That's distant memory, so I might be off on those numbers and all, but I believe that's kind of how the state law set up the small collective thing. Nonprofit, obviously. But what may work so that we don't open up more of this ordinance and intent of the council in keeping these plots small and as personal as possible. Oftentimes an ordinance will have some sort of a hardship provision. So I would suggest some sort of provision that allows some sort of small escape clause for somebody who can say they're disabled and can't get out and can't even reach a watering can or whatever it is to grow their own. Or maybe it may be somebody that's medically necessary but lives in some sort of single room occupancy facility and there's no place for that person to grow it, and maybe they can't travel to a dispensary back and forth. So I think some kind of a hardship clause that would allow, at least on some sort of case-by-case basis, entertaining some of those difficult situations. I don't know if that's something you could do between now and council, but I think it could work without opening, say, a Pandora's box to a lot of other things. And the other comment I have is in responding, Commissioner Schwartz asked other commissioners about willingness to maybe further define some sort of the cultivation site provisions. We have a definition section under A, and I think one of the things that may have confused me is that and there is a definition of cultivation site, which is very good to have, but really all it does is bump us back to the California Business and Professions Code, which I admit I did not look up to try to read. I have no idea what it says, but if I would be fine with adding some more clarity, but I think where it would need to go is in that definitions section to just add maybe a little more clarity on some of those things that were confusing us. Maybe even some of the elements of that business and professions clause. I'm not sure. But with that, I'll be supporting the ordinance regardless because I think it's basically the right way to do this at this particular point in time. I did have one final comment, the delivery, because that came up. The mobile delivery, and I know that's not part of our ordinance now. I believe what you have told us is that we have until January 2018 to deal with that, and so I would say yes, at some point between now and 2018, hopefully without quite the rush we've got today, I think that and maybe some of these other topics could be revisited. Thanks.
If I could just comment on that, Chair Thompson, Commissioner Peugeot, with respect to the 2018 deadline, that's an approximation date. The state has indicated that's when they anticipate licensing, so they could do it a little bit sooner, or they could do it after. So, but yes, if Commission wants us to address it, we will.
Commissioner Higgins, comments?
Thank you, Mr. Chair. I'll be supporting the ordinance. It's not perfect, I guess, as some of my other commissioners have pointed out, but and that it doesn't fly. It flies in the face of maybe the farm-to-table movement or certain sustainable agricultural practices. But it was pointed out it doesn't necessarily conflict with our existing ordinances. We don't produce or manufacture everything under the sun within the city limits, so it's sort of a commerce issue. I don't think we're going to put anybody in any hardships with this particular code, and as was pointed out, it can certainly come back. So I'm a little concerned with the enforcement component of this. I can certainly appreciate the police department's position, but inherently or maybe just anecdotally, we're putting our enforcement staff in potentially dangerous situations. So I don't know how to resolve that without law enforcement. So those are my comments, but I'll support the ordinance.
Thank you. Commissioner Lodge, comments?
Yes, I can support the ordinance. I do like the suggestion of Commissioner Peugeot about making there some exception for a person might qualify as a medical marijuana user because they are physically disabled and because of pain connected with it. So it really seems kind of unfair to then not allow this person to be able to have some way of cultivating their own their own marijuana. Sorry.
Okay. Any other comments? Commissioner Campanella, comments?
Yeah, I understand what the purpose of what we're doing here today. I guess I still have that. That could be looked at separately. I'm sorry. Pardon me. My concern that what we're doing today could, I don't have it in front of me, but could impact the dispensary ordinance relative to the nonprofit cultivation, that is, I believe, is part of that. But again, I'm not an expert on it. I don't have it in front of me. So how do we do we request that you look into that prior to going back to City Council to at least have the City Council be aware that that's occurring and whether they want to affect that particular ordinance at this time, especially given there's 3 applicants in right now. I don't know what their sources of what they're assuming for their sources, but it would seem like we'd have enough time to go back when we're reviewing this, to review the dispensary ordinance at a later date prior to these deadlines to get ordinance amendments made.
I'll personally make sure that your comments around the limitation that this creates in the dispensary ordinance get relayed to the council in our report.
Thank you.
Any other comments? Okay, Commissioner Jordan, comments?
Thank you, Mr. Chair. And I appreciate that. That'll be nice. I just wanted to make sure you had the votes before I talk, because I won't be supporting the recommendation. Which may surprise some people, given my past history of opinion on this subject. But if nothing else, I think it's just a matter of fairness. Somebody said it doesn't impact or reduce the current ordinance, and it does. I think there's 3 counties that you're allowed to source to dispensaries currently right now, and this will take away one of the city limits within those 3 counties. It will change that ordinance as it exists right now, however that works. And I think from a level of fairness, what have been some presumptions made by current dispensaries in the process, from a concern, again, I just have over turning, I guess, my perception of a community-based collective with local sources into a more of a commercial operation whose sources are a county or more away is not what I envision when I reluctantly agree to a medical marijuana dispensary. And the foundation for this goes to great lengths to talk about commercial and personal on many levels. The council discussion went through just residential, ended up discussion on residential, where residential was, not just residential zone. You guys make great pains to distinguish personal and commercial from below and above 100 square feet. We have not really designated dispensaries in the city as a commercial operation, even though they're a business operation, because they are also a nonprofit organization dealing only in a nonprofit status. So there's a lot of hairs you can split either way, I think, my argument or your argument. But for that basis, the sort of the changing of the emphasis on a local-based collective servicing its collective members with sources from the collective members locally, and also then the other point of no provision at all right now for a caregiver to serve a role for somebody who is physically or some other reason incapable of providing their own product and is then required to take part in a dispensary and a sourcing from somewhere else where they don't know where it's coming from and the source of that. So, and I don't disagree with this lightly. I'm not a fan of the product. I'm not a fan of the retail site, and I appreciate that you guys are on a tight timeline. So, like I said, I'm happy to wait until you had the votes and make sure. But this way, at least, I'm sure somebody will sit up at the next conversation and wonder why the heck I didn't agree with it, and maybe read my comments. So, thank you, Mr. Chair.
Thank you. Commissioner Schwartz, final comments?
Yes, thank you. I'll start with the easy stuff, which for me is just tightening up, clarifying, creating more consistency around the language in the ordinance. I've already, I think, identified that, and I see Ms. Ostranger nodding, so I think I've covered all of that. I want to speak to Commissioner Peugeot's thought about a hardship clause. I'm not particularly inclined to support that because I think I can see now, and I can foresee legitimate medical marijuana patients who, not based on a hardship clause, don't want to cultivate it themselves anyway. And I think that should be a right. So they should be able, under the state law or state laws, to obtain the product some other way that they can obtain reasonably, in terms of geographic distance, cost, etc. Here's where I'm struggling the most, and I was listening very carefully to both Commissioners Campanella and Jordan in the most recent set of comments. If we're going to somehow reconsider a personal use as a commercial and commercially licensed and a commercial cultivation practice, then it seems to me our city should do what a number of other cities have done, which is set up anywhere from a business license and or taxing the operation. We don't do that in our city. We didn't do it. We didn't even contemplate it from the beginning. I know because I was on the commission at that time, along with Jordan and Commissioner Lodge. So I think if we're going to go down that road, then, and if the council decides to, what I want to say, negate or dissolve a consideration of a not-for-profit collective being a part of this, then it needs to be considered a business, and we need to regulate it like a business in the ways that we can legally in the city, and that includes license fees and taxes. And unless Mr. Kahlon corrects me otherwise, I don't think we're doing any of that. Well, now we don't have any dispensaries. When we did have dispensaries, we didn't do that. So I don't think we can have it both ways. Here's what I would say to the council. We can't both consider it a personal activity and a personal need and also some quasi-commercial activity without defining is it personal or commercial and then proceeding down two separate roads. I mean, if I need aspirin or ibuprofen, I currently can't create ibuprofen in my home. And if I did, I think that's a commercial, even if it's for my personal use, it's a business. And then there are other implications regarding all of that, and there should be other implications within the city in terms of zoning and public nuisance and health and safety and so forth. So I feel that we're mixing this. The waters are muddied to me the way we're considering handling this. And I don't think it's wise. I don't think it's prudent. I think we need to somehow separate in our own minds and the roads that we go down, personal versus commercial, and everything that goes along with going down two separate paths, legally, legislatively, etc. So I'm having difficulty either fully agreeing with the city attorney's office proposal here and moving forward with this ordinance, and at the same time I don't want to just outright say that I'm opposed to it, because we need to do something. We have to act, and I want us to act so that we don't lose our local control, as you very clearly pointed out to both the council and us today. So I don't know how to reconcile my concerns with what you need to accomplish by March 1st. Unless you tell me, for example, that we can take up these other areas of consideration and concern after March 1. And I don't know if that's too late to do it, because, again, we have 3 dispensary applications making their way through the city's processes right now. So it'll affect them. Whatever happens will also affect them and then everybody else who wants to cultivate.
Mr. Kahlon?
Thank you, Commissioner Schwartz. We as much as committed to the City Council that we would come back with respect to delivery. We also pointed out to the Council as well as the Commission that this state law reserves the already existing power to tax. I think what may be confusing things is that, as I understand and read the state laws, it's a subtle shift away from the collective model to a more commercial kind of model. So I think there's an anticipation or an expectation that storefront dispensaries, wherever they're allowed, will be operating in a more commercial format. That issue may well be something you want to address with our dispensary ordinance at some point in time. I can't commit to bring that back without council direction, but that's, I'm sure, something you could recommend to the council if that's your concern. So I don't see so much of a mixing up of the issues as a change in the form of the conversation forced on us by the state law.
Well, if it'd be appropriate, then my recommendation would be that for, I don't know if I should say, all other aspects that are identified in the new legislation, separate from cultivation, we'll handle cultivation now because we need to retain local control. But everything else, both a revisit of our current ordinance and all other aspects that are identified in these three pieces of legislation that we can revisit and we can legislate or regulate, I would highly recommend this commission do it as early as possible after March 1 of 2016. I think there are a number of unintended consequences. I know your office, Mr. Kalan, has done a lot of work here. I appreciate Ms. Ostranger. I watched the council hearing, et cetera. But I think there's more work to be done, and I suggest we pick that up as soon as possible after March 1. Thank you.
Okay, if there are no other comments, I'll make a couple of brief comments. I agree with Commissioners Peugeot and Campanella that we should include some hardship clause, if you want to call it that, for people who are legitimate users who are actually unable to cultivate their own. And I understand that at some point they can get deliveries, but that's still a very muddy area, as you readily admit. Second point is that I concur with Commissioner Jordan's position that local sourcing of the local dispensaries is something that we should consider, but I don't want to delay moving this forward at this time and due to the state deadline. And apparently the council doesn't necessarily agree with that position at this point. I also want to make the observation that this is a very rapidly changing area, and I expect state law and federal law and our ordinances in response to those are going to be changing over the next several years. So I'm sure we're going to be dealing with this as it evolves. So with that, I would like to ask for a motion that we recommend introduction of this ordinance to the City Council for review. Commissioner Peugeot.
Thank you. I'm ready to make a motion. I do have a council question before I frame the motion. If the motion included language to include a hardship clause, is that specific enough, or would we need to have exact language for you?
Commissioner Peugeot, at the risk of loading up your conversation further, the concern about a hardship clause is who's going to administer it and how will it be administered. So the fear is that if we create some sort of permit process, we need to then regulate who has a hardship and who doesn't. That means dragging somebody who is presumably incapacitated in front of the city to get a permit to do what they can't do on their own. I think that that's why our recommendation is to defer that issue to the dispensaries that will be available, and I would defer the hardship question to how you work on the delivery issue when that comes back to you. I think the hardship is addressed by allowing home delivery from dispensaries within or outside of Santa Barbara. So I would urge the Commission, if you want a hardship clause, I'd need you to be very specific, but I'd urge you to recommend council consideration of that in connection with delivery services so that there is a lifeline, so to speak, for those who are incapacitated and can't get out to a dispensary on their own or can't grow on their own.
Okay, thank you for that. With that, I will make a simple motion to recommend introduction of the ordinance and have that forwarded to council, the ordinance as is. I'll make the motion that. And perhaps following the motion, we might have just perhaps another recommendation to council. I would propose as a second motion to outline those items of concern and maybe even perhaps prioritize the hardship part. So anyway, I move to recommend that the draft ordinance be introduced and forwarded to the city council.
Second.
We have a motion and a second. Is there any discussion? Commissioner Schwartz, discussion?
Yes, to the maker of the motion, I'm wondering if you might consider what I've identified. And again, I thought I saw agreement with Ms. Ostringer, and that is to create clearer, consistent language in the areas I've already discussed around the 100 horizontal square feet and how contiguous 100 horizontal square feet, wherever that is referenced in the ordinance.
I'd be in support of that change if it could be accomplished rather in a straightforward way. Do you have enough information to make those changes now, or would we have to?
Yeah, I think we could add that. I think Commissioner Schwartz, if I understand, was very specific in that she wanted the language of contiguous horizontal square feet in there for both indoor and outdoor, and to have that appear throughout the ordinance.
Yes, that was my intention.
I would be willing to amend my motion to include that then.
Commissioner Lodge, is
Yes.
that acceptable as the seconder?
Yes.
Is there any further discussion? Okay, all in favor of the motion?
Aye.
Aye. All opposed?
No.
Any abstentions? Okay, Jordan opposed. And you said you wanted to make an additional motion, Commissioner Peugeot?
Yes, I appreciate that City Attorney's Office has offered to list and forward some of our areas of concern to the council when it goes back before them. And I would like a motion that confirmed that we would like that done, and also in a particular of a couple ones, and maybe others would like to add. For me, the concern about the hardship clause for is a priority on the top of my concern, so I would definitely like that added. And a secondary concern I have is this awkwardness with the jurisdictional issues in future deliveries and truck trips and whatnot, basically forcing some of those to be outside the boundaries of the city. So those would be my top two, and I don't know if anybody else would want to add to that list, but if we could maybe create a more finite list that you would be presented to them, that's what my motion would include.
Okay, that's your motion. Commissioner Schwartz?
Yes, thank you. I wanted to comment on that. I'm just going to entrust the city attorney's office that they've captured all of our comments today. But in looking at this item going to council January 12th, personally, I would like to see the list of items that you've captured from today that are going to council before council gets its package. However, I don't know if that's feasible given the vacation time frame that we're looking at and when you would have it prepared in time for them on January 12th or 1 week
Okay,
prior,
we have a
which is-
motion on the floor. Do we have a second of the motion?
I'll second the motion.
And we have a motion and a second, and I assume, Commissioner Schwartz, that you're carrying on discussion of the motion.
Correct.
Commissioner Campanella, discussion?
Discussion, if the maker of the motion would like to include the fact as promised that the impact upon the current dispensary ordinance is considered by the city council, and I'll add words prior to a blanket prohibiting that they consider what the impact on that ordinance can be.
Very good. I'd be willing to add that to the motion.
And Commissioner Lodge is the seconder?
Yes.
Okay. Commissioner Schwartz, further discussion?
Well, I just wanted to hear from the city attorney's office if they think it's feasible for us to see this comprehensive list before the package is sent to council, so we can make sure it's comprehensive.
Well, I think the commission's done a good job of laying out its concerns. I have three in the second motion. We can certainly recite back that motion in relatively short order.
Okay.
What we can't do is give you a list and have you all comment on it and then
Right.
adapt to it, obviously.
I understand. Okay, thank you.
And the council staff report will be available when it's prepared, so you can review it at that point. Okay, any other discussion? All in favor?
Aye.
Aye. Any opposed? None opposed,
I'll
unanimous.
just abstain from that vote. I got lost in it.
Jordan, abstention. Okay, any final closing comments from the staff? Mr. Cologne, any closing
I appreciate
closing
the
comments?
commission's hard work. This, given the time frame, this ordinance was drafted on a lovely Sunday, and we tried to be as tight as we could. You've picked up some areas where it could use work, and we'll take that for the gospel it is.
Well, as I said, I don't think we've seen the end of this whole topic. We're going to be seeing it on and on for the next several years. Okay, that completes that item. The next item is the staff hearing officer report.
Nothing extraordinary to report. Three relatively tame items. Last week, one of them actually involved a parking issue for a church use on East Gutierrez Street that I had some conversations with staff and I was ready to pull up, but we negotiated some additional language and staff went back to the applicant. The applicant had no problem agreeing to it. So I guess I'm just publicly thanking staff for being flexible enough to respond to my input and help avoid the applicant from having to make a planning commission appearance. So thank you, Mr. Chair.
Thank you. Any other committee or liaison reports? Commissioner Campanella?
Thank you, Chair Thompson. At the Architectural Board of Review, the last meeting on November 23rd, 3869 State Street, the Housing Authority project on Upper State, received final approval with conditions, and the board also found that further environmental review under SECRO was exempt on that. So that's the status of that project. Also at the same meeting, 3714 State Street, the Sandman property, also received final approval, was continued indefinitely to consent review with some comments, but that's on its way towards, more of its final approval. Coming up next Monday, there's two AUD projects, two small ones that were recently added to the list. 226 South Voluntario, that's taking two existing units and converting it to 5 units. And then on 510 East Ortega, there's one existing residence that's going to be removed, and there'll be 5 units in its place. This is the initial concept review for both of these projects. And along with some of my fellow commissioners, the new zoning ordinance, there's meetings that are coming up next Monday and the Monday after, 9:30 to 12:30 at Louise Lowry Center. This is Module 2 in our discussion of 3 modules, which is going to be an overview discussion on what's being proposed, getting our comments, and then this will be coming back to a community meeting and planning commission meeting as we did on Module 1 for comments. Next Tuesday, Commissioner Jordan and Commissioner Schwartz and I will be reconvening with the Housing Subcommittee. Mr. Dayton is going to be attending and talking about parking issues, which, as we found out at City Council meeting, is one of the questions or concerns that have come up relative to the AUD program. And then I think that's about it for now, except multifamily design guidelines. We need an outside consultant on that, and that likely is going to wait until the budgetary process for next fiscal year, which would be starting in February, when budgets are put together and the request for an allocation of funds would be made. So that is pretty much on hold for this time. Thank you.
Mr. Chair, if I could
Okay.
just interject too on the Sandman project, whatever that 34 or 3800 block of State Street too. I'm by that project on State Street probably 3 or 4 days, work days a week. And if somebody was looking for a project that manages its presence on the street for a large project, that is a poster child project to me. Its fencing, its method of gating, where it's got a sliding gate rather than a pivoting gate, its signage, the way they're keeping that site up is just a wonderful job. It's a busy street. They've had occasion to be out in the public right-of-way, cutting down one lane at times. They've managed that really well. And it's a large project, so it has a lot of resources to put to that type of thing. But for where it is and the impact it could be having and the visual blight it could be causing in that part of town, it's so far up till now. The demolition is down to dirt now in that lot, but they've done a great job managing that project site.
I would concur. Commissioner Schwartz?
Yes, two liaison comments. First, with the next Water Commission meeting taking place on the 14th of this month, and with the Planning Commission not meeting subsequent to that, it'll be in the new year that I'll be able to give a report out on the December Water Commission meeting. And some have asked what the status is on our local coastal plan subcommittee work that Commissioners Thompson, Peugeot, and I participate in. And because we've received an extension from the Coastal Commission on our work, that's allowed us a bit more time. So we'll be meeting again in the new year with staff, and we'll, I'm sure, be providing an update to the Planning Commission as soon as we're at a juncture where we can bring some substantive status reports to the Commission. Thank you.
Thank you. Any others? I would just remind everybody today's first Thursday, so there'll be a lot of activity downtown. And we are adjourned until next Thursday, the 10th, at which time we'll be discussing the final draft of the Bicycle Master Plan. Thanks.